basically, long story short, we picked up, the client says she filed charges, but then, when we asked for bail, the charges weren't filed for harassing her. So I sent you over the harassment videos and
Whoa. Whoa. Whoa.
It was like a FaceTime call with his daughter.
Where are you? Here we go.
So she sent screenshots and then.
Okay, hold on.
Oh, that's business. If you scroll down to the very bottom, you'll see like the videos and then those are your screenshots.
Yeah, oh, I see. Yeah. Let's pull it.
Council for reset.
Yeah, here we go.
There's
Is it here?
It's just the first one in like the grade.
Travis Robinson. Why you're here, Mr. Robinson? Think. Do you know why you're here?
Right out the gate, the judge reminds him he's on probation for harassment. And the big question is simple. Did he cross the line again? Or is this just a custody misunderstanding spiraling out of control? Buckle up.
Been bothering her or something. That's the only thing I can assume. I honestly do not know, Your Honor. I've been doing my classes. Just thought about probation. Been trying to do good.
You were on probation for harassment. Can I give you a cause number?
Yes, please.
It's 247-4460. Mr. Travis Robinson was placed on probation for harassment in March of this year. What did we ask you not to do? Right. Have you been bothering her?
Between our child together. I think she must have not liked that I was trying to ask for my FaceTime that is from child support orders. And I guess she must have thought I was harassing her from me continuously asking or calling to get it. And I think that turned into harassment.
This is the moment the judge drops the hammer. She says you harass me, Mr. Robinson. Notice how the judge isn't just asking questions anymore. She's making a finding. That means the court already sees a pattern here.
It was nothing towards her.
What does harass mean, Mr. Robinson? Over, and over, and over, and over. Secret in the jury box. I'm gonna get you a lawyer today.
So right there.
Please appoint someone to Mr. Robinson, please. We need to have.
Hey, Mr. Robinson, he is on a defer for harassing.
Oh, okay, got it. You
And
got
I
it.
talked to the chief, and it looks like there hasn't been a formal motion yet, but that's
I have
coming.
one right now.
Okay.
But I need to email this to you first. So I want you to look at it and then talk with him about it.
Okay, I will revisit you on that one. Let me look at everything.
Let me send it to you real quick.
JD Law.
Yes, Andre?
Oh, I'm sorry. Come on.
No worries, Judge. We were talking about that anyway, but Judge, I did, Mr. Robinson, Travis Robinson on, Judge, according to Mr. Robinson, he's been complying with
Now this is where it gets complicated. His attorney pitches the FaceTime defense. That he wasn't harassing, he was just trying to access his child. But legally, intent matters. But impact matters more. 20 unanswered calls can look like desperation or harassment. And guess who decides which one? The judge.
non-threatening harassment on this particular situation, per the Attorney General's office and part of his compliance in child support, he gets 15 minutes of FaceTime with their mutual child. And that's all he was trying to do, was just to try to call her so he can get his 15 minutes. Now, that's what he's telling me. I have no way to verify any of that, Judge. I just heard all of that this morning. But, you know, it kind of makes sense to me. I showed him the video with him calling from 7:30 to 7:45.
I had a lengthy conversation with him prior to getting on probation that in the event she failed to comply with what he was able to get as far as FaceTime, that he was to go to the family court and use them as the avenue to either hold her in contempt, have her fined, jailed, whatnot for non-compliance with their custody agreement.
I agree, Judge.
He was not to take matters into his own hands.
Well,
And
all I can tell you is based on the call logs that she screenshot over and I looked at what you sent me, it shows that from 7:32 to 7:40-ish something that he made these series of calls. There's no way we can tell because she declined all the calls. And I said, well, you know, you're calling a lot. And he goes, yes, because I was trying to get through the FaceTime so I can talk to my child as part of my child support compliance. That's all I was doing. I never made communications to her, didn't even have words with her.
Here the judge gives the audience a gold nugget of legal reality. 20 calls in 2 minutes is harassment. And honestly, that's the law. Courts don't care if your intentions are pure. If the behavior causes emotional distress or fear, it becomes harassment. This is where Mr. Robinson's case really starts sinking.
20 calls in a matter of 3 or 4 minutes.
But if you're trying to get a whole, to me, it's reasonable, Judge, because he's trying to get through.
Many times is not reasonable. Well, come up, Mr. Robinson.
If he was trying to get through FaceTime, he would keep trying because he only has that allowed time to get through to see his daughter.
I told you the last time you were here that in the event she was non-compliant with your custody arrangement, you were not to take matters into your own hands with the repeated 20 to 50 to 150 phone calls that you do. I have proof to the contrary, Mr. Robinson. And if something is happening to where she is busy, that she cannot get a hold of you, how do you know that she's not having a crisis of her own? For you to call 20 times in a matter of a minute or two is harassment.
Thought through this, think of situations. Like she could have been busy, baby could have been sick. That's why she didn't.
Now it's a little bit too late.
Myself instead of.
Ma'am, he goes with you. Bye-bye, Mr. Robinson. You didn't get it last time.
Yeah,
See if it happens this time.
So let me figure it out.
Ma'am, ma'am,
You
don't set him down, please.
Take care of this one, Judge, and then I'll come back.
I'm gonna scare her.
You want to think about it?
Give me 30 minutes.
But I've talked to Mr. Robinson. He is truly remorseful. He knows he didn't make the best judgment. He did get a new job at Cracker Barrel on the town center in 59. He's terrified that he's going to lose it. He has to go to work at 9 in the morning. His mom is actually waiting.
Mom's here?
No, she's in the car downstairs waiting all that. So I told him that I would. I just wanted to kind of update you what I found out more. He is, you know, in terms of AG and
complaining witness is absolutely fed up with him calling and calling and calling. And how many, do you have the case pulled up?
Judge, if we, you know, give him amended conditions like 0 tolerance, 1 too many times, and he's going in, I mean, anything, I mean, I saw it, Judge. I get you. I mean, but again, if there's this FaceTime thing that he's just trying to see his, you know, see his daughter. But I mean, why don't you just say, you know, besides the no contact, I mean, the FaceTime, just don't have any communication with the ex, and that way they have some space, and he's only allowed to call during the FaceTime time. And if that's not
The
possible,
problem is that, Shatoria, what did we tell him that he was not allowed to contact her only for purposes of the visitation? What do we do now?
But I think it's, harassing the third.
Well, that I know, yeah. I mean, because
That 4066.
I'm trying to pull it up right now.
4066.
This part is wild. Watch how the judge and attorneys wrestle with the idea of no contact except FaceTime. But even that fails because the judge says she doesn't trust him anymore. That's huge. When a judge says, "I can't trust you," you're one step away from cuffs.
Yeah, sorry, man, I'm trying to pull it up. 247-4460. That's, maybe no contact except for the time.
I don't think he's incapable of having contact without, so maybe we should just do no contact at all.
Yeah, that's what I was saying, that no contact except for
Didn't add anything about.
All we did was just no threatening, harassing, abusive contact, and that's obviously.
They have, like, as part of his child support, he has 15 minutes of FaceTime, and that's the time.
Do you have
It was still 2 minutes.
personally?
The probation officer did and just gave me the password.
Okay, so I'm now gonna modify the conditions, no contact whatsoever.
Yeah, exactly.
He's incapable of doing it unless, so now I can't trust him anymore, so just no more contact. He's gonna have to find another way to have contact with the child.
And if he doesn't want to sign, then how do you want?
Well, then I'm gonna put him in jail. I'll keep him. That's it.
Judge, we have a
Tell me.
possible solution.
I was gonna say just no contact.
Well, I mean,
It's okay, Kevin, tell me what you're thinking.
is there an established time that he is supposed to contact? Because if she's just willfully withdrawn, not allowing him.
I don't know. We don't have,
Judge, I think there is. I think it's that during that time frame.
can you from him now get a copy of the custody order, or perhaps I can look at it?
I don't have that, but maybe what we can do is bring him back and tell him to bring all that and set a very specific time for that contact, only to be for the purpose of parenting the child.
Okay, I'll agree to that. But until we're able to formulate the plan, no contact.
Yes.
So
How about if we bring him back later this week, give him a chance to give me all that stuff, and I'll work with, probation to put that in place. Would that be okay?
Yes.
All right. Should we bring him
mind
out?
grabbing him, please?
Thank you, Mr. Rowe.
Every father should have the right to have access to their kid. But you can't do what you're doing. I mean, that's just not cool. That's not cool. Now, if she is truly withholding, you have to find the right avenue to do it. Calling 100 times is not it. Tell me while we're waiting.
He went and tested negative for everything.
Wonderful.
And he
Good
had,
job.
so,
Keep it up. Or just, I guess, have him wait right here and then I'll talk. I will never play this game with you again.
This is the judge's final warning, the nuclear level warning. If I see you again, you're getting a lengthy jail sentence. That's not a suggestion. That's not a friendly reminder. That is a legal promise. And the judge rarely says this unless she fully believes the defendant is a repeat risk.
If you and I see each other again, I'm assuring you a very lengthy jail sentence. No means no. Doesn't mean maybe. Doesn't mean she's got my kids. There are proper ways to fight someone who doesn't want to give you access to a child. Calling 30 times, 50 times is not the way to do it. We are going to try to formulate a plan to help you, Mr. Robinson. Until we have done that, I don't want you to have any contact with her whatsoever. Do you understand? What we're going to do is we are going to postpone your case until Wednesday.
Thursday, Judge.
I'm gone Thursday. I'm not gonna be here.
Friday?
I'm not here Friday either. I'm gone. I'll be with a bunch of 12, 13-year-olds in San Antonio.
Will you come back next week, next Monday? I'm just trying to, because I will.
I'm okay with that as long as he realizes that you cannot have contact with this person until Monday.
But next week,
I'm okay with that, but
can we,
no contact means no contact, Mr. Robinson.
That's the 6th, May 6th. That's when.
I will do
Monday, yeah,
whatever,
Monday's good. I'm off on Mondays.
then Monday it is. But this is what we're going to do. I want you to come back Monday. I want you to bring me a copy of your custody and visitation order. I want to see what the judge set forth as you being able to have access to the child. We will set a plan in place because our probation officer has the ability to contact Michaela. We will try to set forth a plan so that you can have access to the child without you having to call as many times as you have been. All you're doing is you're alienating her even more, where she's going to restrict further access. You're going about things the wrong way. Do you think someone wants to have them contact 50 times? Right. Do you think that's going to have them resent you more? Yes. So we're going to try to create something for you. On Monday, when you come back, bring me a copy of the order. We'll see what the judge said as far as time is concerned. We will also reach out through the probation officer to her to make sure that she knows this is the proper time. He will only be able to call you at this time so that there are no issues. And if then she continues to restrict your access, somehow we will help you get to the family court so that you can have her held in contempt for willfully withholding and violating the court order she's got and you have. Do you understand?
Yes, I understand.
If at that point she still is giving you, if she's not giving you access, you go to the family court and they will hold her in contempt. Okay.
Thank you, Judge.
No contact until we get something set up. Okay? All right. You can, please. You can let him go.